You may be seated. Mr. Dieters.
Good morning, everyone. I'm going to join the chorus of thank yous for what you guys have done the last couple of weeks, and I know that you set aside a large part of your lives and had to put up with some nonsense concerning issues you should not be concerned with, but unfortunately in the world today that's becoming more and more common. But I just wanted to thank you on behalf of the state of Ohio for what you've all have done, paying attention. We notice those things sometimes, and we really appreciate it. You know, there's so many things about this case that makes it unique. We have a former officer charged with murder. Very unique. We're using a technology in this case that is pretty new. It may be commonplace in the future, but this is new stuff for a lot of people involved. And you know, the emotions are high in this case, and it seems like everyone around has an opinion about it, but you all have heard the facts, and you are the trier of fact. And as you sort through this, the good news is that you will have a clear pathway to getting to where you need to be. And it is a tried and true method that has been used for hundreds of years. First of all, you have to listen to what Judge Shanahan says the law is. You sat through all the facts. You can choose to believe or disbelieve anything you want concerning the facts. It's your job to search for the truth. It is your job to search for the truth, and that's what I hope you do. As you have heard before, and voir dire, and Judge Shanahan will tell you again, you may not permit sympathy or prejudice to enter into your decision. You may not even consider punishment. For instance, it would violate your oath if you said something like, "Oh, he looks so young," or "I wonder if he's going to go to jail." That's not your job. I don't like people who have marijuana in their car. Cops deserve a break. Sympathy has no place in this courtroom or in your deliberations. Factors outside of your instructions must be ignored, no matter how hard that may be. You swore to that, and we counted on that when we selected each and every one of you as jurors. When we were thinking about our closing arguments, Mark and Rick and I decided that Mark would lay out the elements of the case of every crime we had to prove, which he did this morning. And I think you could see what a good prosecutor Mark is and Rick is, why the county's blessed to have them. What I want to do now is to lay out some observations about what the evidence that I think is important when you go back there and analyze and think about all the evidence you've heard. The first thing is this: you are going to have all the exhibits, clothes, photos, diagrams, videos, and the rest back in the jury room. The judge, and I'll touch on this briefly, has permitted expert testimony in this case also. And you will have Grant Frederick's report back there that you can view. I think Grant Frederick was an impressive expert who analyzed the video and the video evidence in this case. And although the defense had every right to call a video expert, they didn't. We called a police use of force expert in our case. Again, very professional, very impressive. They called an expert on the police use of force, which we refer to as the volunteer expert. He has never testified ever in his life against a police officer. He was upset with the indictment, thought he was innocent by watching something on TV in Columbus, Ohio. He wrote his report 10 months before the video expert had prepared their report so he could see what it was about. The judge is going to tell you that you can believe all, some, or none of his testimony. And I would suggest to you that it is worthless. In the face of a very clear video, and you're going to have this all back there. Thank God for the body camera. He claims Mr. Tenzing was dragged. It never happened. He said he had to stop the threat. There never was one. Even Mr. Tenzing, in the overwhelming face of obviousness of the video where it's clear he isn't dragged, now has changed his story. Yesterday, for the first time, we heard it was his perception he was dragged. Look at the statement that said police homicide took 2 days after this incident. What happened? He was very positive of that. He was very positive of that. But when you see the video compared to that statement and hear from our expert who does this for a living, that story just doesn't cut it. So now we're down to perception, not reality. So you moved to your plan B, now we're dealing with perception. I was dragged. I was perceived as being dragged. Give me a break. The defense has become almost so comical with their word games. When you intentionally aim a .40 caliber gun at someone's head, pull the trigger, you're not killing them purposely. You are now stopping a threat. Let's just cut to the chase here. You are going to hear exactly when the gunshot happens. You are clearly able to see exactly where Tenzing was and was doing when he pulled the trigger. Go back there and watch it 100 times. Hey, put that frame up. Go to the next one, Peg. Does this look like that fantastical story he told yesterday, where he's laying on the back and doing some he is being dragged, he has to reach up around and shoot Sam? You know, as the finders of facts, I like to use this analogy in front of juries. You are like surgeons doing your job over a patient. And the defense is trying to throw red pepper in your eyes so you can't see the truth and do your work. What in this case is the red pepper they're throwing in your eyes? the volunteer expert, self-admitted he's not a video expert, who never testifies for anybody but a policeman, rendering some nonsensical opinion totally contrary to the video. He wrote the opinion 10 months before our expert laid out the video for him. How about the defendant's story? After being absolutely firm of the falsehood that he has perpetrated for months. Now he sees what the jury sees and realizes that this junk story can't stand up in the face of overwhelming evidence. Now he claims now it's just his perception he was dragged. You know, one of the greatest tools you can use in judging the truthfulness of somebody is the consistency of the story, and a number of times they've told the same story. You think these witnesses were coached? My perception, stop the threat. And this is new for me, but I heard it from multiple witnesses. Mash the accelerator. I've never seen him so white and pale. Here's some of the other pieces of red pepper that's been thrown at you, and I'll touch on them briefly. We tried to interject race. We did. The state of Ohio did. I wasn't wearing that shirt. I didn't collect that shirt from him that day. The criminalist did. It does have probative value. Take a look at it and see if it's damaged in any way from being dragged 20 feet. They're the ones that introduced his character. We can't introduce his character until they did it. And we're sitting here with a report from the University of Cincinnati where his racial disparity of pullovers is larger than anyone else on the force, and he has more citations than anyone else on the force. They place his character at issue. They show prior stops he made. Both, remarkably, African-American drivers with no front license plate. And you know, just as an aside, the guy's with his wife and his 4 kids. Does he really have to handcuff the guy in front of his 4 kids? They placed his character at issue. Not only did we not, we couldn't. Mr. Matthews talks about reasonable doubt. Judge Shanahan's going to explain to you exactly what it is. It's not that complicated. To sum it up, and she'll tell you, you just have to be certain, because everything is up to possible doubt. You just have to be sure. That's all you have to be. Some more of the red pepper in your eyes. It depends on what drag is. It reminds me of that question, it depends on what is. I think everybody knows what being dragged means. But he was either perceived to be dragged or dragged. That's all we know. You know, one of the last vestiges of a desperate defense is when an expert gets on the stand and you say, how much have you been paid? I got news for you. I know you guys aren't getting paid much. Everyone here's getting paid. I'm getting paid. Mr. Matthews is being paid. The judge is being paid. I don't understand the purpose of that. I don't understand it, except to confuse you, as if something's wrong with an expert because he got paid. Another piece of pepper. He had to have turned the tires. You know, don't leave your common sense at the courthouse steps. You can apply your common sense to situations like this. We're dealing with a car that had over 200,000 miles on it. All right? Do we know what the alignment was on that car? My brothers and I, all through college, drove a car that if we didn't turn the wheel physically to the right, it would have gone left, hard. We just didn't have the money to fix it. And when Grant Frederick said that the car rolled slightly, maybe 1 or 2 feet before the shot, don't leave your common sense. When you start your car and you put it in gear, does it sit still? Without even touching the accelerator. Without even touching it. Don't use 20/20 hindsight. That's called a trial. That's what we do in every trial. We look back on behaviors and make a decision. Present our case to a jury, argue the case, let the judge describe the law. That's what we do in trials. Then we heard that Ray Tenzing feels terrible. Didn't come from him. He was on the stand yesterday a long time. I never heard him say one thing about that. But you are the sole finders of fact, as I said, and nothing we say is evidence. Nothing Mr. Matthews said was evidence. Rick, Mark, and I have been doing this a long time, and this case will be, for me, always something, for many reasons, on many different levels, I'm not going to forget about. But evidence-wise, there are 3 things I will take away from this case. 2 are testimonial, and 1 is an exhibit. First of all, the testimony of the defendant. It's not the fact that now we're dealing with perceptions instead of reality. It's not that. It was the tears. You're going to have a video of his questioning, pictures of him at the hospital, videos of his questioning 2 days later by the homicide. You tell me if he's upset. The place to be upset, I think, if you use your common sense, would probably be at the crime scene after you just blew someone's brains out. But that's not what happened. He wasn't crying yesterday for Sam or his mom, his fiance, his brothers, his sisters, or his kids. He was crying only for himself. They were not tears for the life he took, but it was for the life he was trying to save. The second thing that's going to be hard to forget about was also testimonial, and that was Alicia Napier. She's totally uncompromised by any bias or prejudice, unlike his expert. and I want to add something real quick because there's been some discussions about the responding UC police officers. People have asked me if I thought or we believe that they were lying. And I'll tell you that in the heat of the moment, I think some people get confused, but you're going to have the film. Go in the back, play it at real time, listen to when the gunshot goes off and when the car accelerates at a high rate of speed. It's very clear. Anyway, going back to Alicia, she saw the stop. She saw Tenzing standing next to the car. Remember that he was standing very close to the car. She saw Tenzing struggling to pull his gun, however short a time. Then she heard a gunshot. She saw Tenzing falling away from Sam's car. She actually thought, as Mark said, that Tenzing was shot. She never saw any dragging. She was an incredibly frank, unbiased, fair witness who didn't have to come forward. When I asked Tenzing about it yesterday in my cross-examination, his only answer was to explain her observation was, well, she saw it through her rear view mirror, her side view mirror. So what? There's an excuse for everything. The third thing I'm going to remember is not testimonial, but it is an exhibit, the body cam, and how the expert was able to break it down. The video is the ultimate witness. It doesn't alter reality or change its story. It has no bias or prejudice. It consistently tells what it saw, whether it's the first time or the 1,000th time. And you will have this ultimate witness with you in the jury room. I'm sure in the future this technology is going to be commonplace, and maybe my kids will, when they try cases, will be using it. But just like I said in the opening, this video exposes Tenzing's lies. After 2 days later, it's too bad Sam didn't have that luxury of 2 days, isn't it? He wanted answers right now, right now, right now. He kills somebody, he gets 2 days. Go talk to a lawyer. 2 days later, even after seeing the body cam, he says he reached through the steering wheel to turn off the car. Proven false. His left arm got tangled in the steering wheel. Proven false. The car sped off with him stuck. Proven false. He was being dragged along the pavement by his left arm. Watch the timing of the video and the timing of the shot in this video. Remember Alicia's testimony and look at his uniform. It's pristine. That was proven false. How his body was almost parallel to the ground. It's false. How then, hanging on for dear life, he pulled his pistol. Does this contortionist move? Why did he have to come up with that ludicrous story? That he has long arms and he had to reach all the way up and then bend back down? Mark demonstrated perfectly. I'm glad I'm not going to get on the ground like Mark did. But, it's simple. He has to explain the path of the bullet. Bullet comes up here, goes down here. So what's the likely result of shooting another in the head with a .40 caliber semi-automatic gun? More word games. Stop the threat. How about they're going to die? Because that's what's going to happen. Look, the evidence is overwhelming that Raymond Tenzing purposely killed Sam DeBose. And the evidence is overwhelming that there was absolutely no justification for it. One last thing. The defense is urging that you determine that there's justification. Our job in proof, to prove beyond a reasonable doubt, is the murder and or the manslaughter. If he alleges, and the judge will instruct you, if he alleges that it was justified, the burden shifts to him. If we prove that he purposely killed Sam, the burden, and he says it was self-defense, the burden shifts to him. And by a preponderance of the evidence, he has to prove to you that's what happened. You know, everyone in this courtroom has a job to do. We do, Mr. Matthews does, the judge does. The only way the state does not get the justice that is cried out for is if any of you refuse to adhere to your oath and that you swore to follow the law. Apply the facts, follow the law as the judge instructs, and if you do, you will find Ray Tenzing guilty of murder. Thank you. Thanks, Judge.
Thank you, Mr. Peters. Ladies and gentlemen in the gallery, I'm going to instruct the jury you will not be permitted to exit or enter the courtroom during that time. So if you would like to leave now, you need to do so. Members of the jury, you have heard the evidence and the arguments of counsel. It is my duty to instruct you on the law that applies to this case. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment merely informs the defendant that he has been charged with a crime. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts in issue all the essential elements of the crime. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence that convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely. Strike that. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. What is evidence? Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any stipulations entered into by counsel. State's Exhibit 9A is the video recording of the defendant's interview with Cincinnati police on July 21st of 2015. Several breaks were taken during the interview, and during some of those breaks, the defendant was present in the interview room with his attorney. By the agreement of the parties, those sections of the interview have been redacted from the interview. There is also a few-minute segment of the interview where the officers are questioning the defendant about damage to his uniform, where the video did not record what was taking place, but the audio is functioning properly. Both sides agree that the complete audio part of the interview was recorded on this disc, and the only thing missing is a few minutes of video. Evidence may be direct or circumstantial, or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Evidence may also be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other reasonable facts or conclusions. Circumstantial evidence and direct evidence inherently possess the same probative value and therefore are subjected to the same standard of proof. Where the evidence is both direct and circumstantial, the combination of the two must satisfy you of the defendant's guilt beyond a reasonable doubt. You may not make one inference from another inference, but you may draw more than one inference from the same set of facts or circumstances. The evidence does not include the indictment, the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements and answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. A number of exhibits in the testimony relating to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as originally taken. You will determine what weight, if any, the exhibits should receive in light of all the evidence. Recordings and testimony relating to them have been introduced into evidence. You shall consider whether the recordings are a true record of what transpired at the time they were taken. If you find that they are, you will then determine what weight, if any, the recordings should receive in light of all the evidence. Generally, a witness may not express an opinion. However, one who follows a professional or a special line of work may express his opinion because of his education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. Questions have been asked which expert witnesses were permitted to assume that certain facts were true and to give an opinion based upon such assumption. You must determine whether the assumed facts upon which the experts based their opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the experts. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining its weight, you may take into consideration their skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of the defendant is to be weighted by the same rules that apply to the other witnesses. The indictment charges that the crimes alleged took place on or about the 19th day of July in the year 2015. It is not necessary that the state prove that the crimes were committed on the exact day that is charged in the indictment. It is sufficient to prove that the offenses took place on a date reasonably near the dates claimed. The indictment also charges that the crimes took place in Hamilton County, Ohio. Before you can decide whether the state of Ohio has proved beyond a reasonable doubt all of the essential elements of the offenses with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the crimes were committed in Hamilton County, Ohio. The right of this court to try the defendant depends upon the proof that the crimes were committed in Hamilton County. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count, uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. The court will now outline and define the specific issues involved in this case. Count 1. The indictment charges the defendant in count 1 with murder, a violation of Ohio Revised Code Section 2903.02a. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 19th day of July in the year 2015, and in Hamilton County, Ohio, the defendant purposely caused the death of Samuel DeBose. Purpose is an essential element of the offense of murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of another. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result or engage in a specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person, unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means or weapon used, and all the other facts and circumstances in evidence. You may infer a purpose to cause the death of another when the natural or probable consequence of the defendant's act is to produce death in light of all the surrounding circumstances. Such circumstances include the weapon used and its capability to destroy life. If you find that the defendant used a deadly weapon against another in a manner calculated to destroy life, you may, but are not required, to infer the purpose to cause death from the use of the weapon. Whether an inference is made rests entirely with you. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon, or possessed, carried, or used as a weapon. A deadly weapon is any instrument, device, or thing that has two characteristics. The first characteristic, that it is capable of inflicting or causing death. The second characteristic is in the alternative. Either the instrument, device, or thing was designed or specially adapted for use as a weapon, or it was possessed, carried, or used, in this case, as a weapon. These are questions of fact for you to determine. Proof of fear or apprehension on the part of the person against whom the weapon is used or threatened is not required. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Where an act is a crime, a good motive or purpose is not a defense. Cause is an essential element of the offense of murder. Cause is an act or failure to act which in a natural continuous sequence directly produces the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. The defendant, Raymond Tenzing, maintains that his use of deadly force against Samuel DuBose was reasonable and lawful in the exercise of his official duties as a police officer and therefore justified because he feared that the actions of Samuel DuBose would cause death or serious physical harm to the defendant. To establish this defense of justification, the defendant must prove that he was justified in using deadly force by a preponderance of the evidence. Preponderance of the evidence is the greater weight of the evidence. That is, evidence that you believe because it outweighs or overbalances in your minds the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. In determining whether or not an issue has been proved by a preponderance of the evidence, you should consider all of the evidence bearing upon that issue, regardless of who produced it. If the weight of the evidence is equally balanced, or if you are unable to determine which side of an issue has the preponderance, then the defendant has not established such defense. If the defendant fails to establish the defense of justification, the state still must prove to you beyond a reasonable doubt all the elements of the crimes charged. The standard of law to be applied in determining whether the use of deadly force by a police officer is justified is as follows. Deadly force may be used if the officer reasonably believes that such force is necessary to defend himself from the actual use or imminent use of physical force by the suspect that poses the threat of death or serious physical harm. If such circumstances exist, then the officer's use of deadly force is not unreasonable. The test of reasonableness requires careful attention to the facts and circumstances, including, but not limited to, the severity of the crime that the defendant police officer was addressing, whether Samuel DuBose posed an immediate threat to the safety of the defendant police officer or others, whether Samuel DuBose was actively resisting arrest or attempting to evade arrest by flight, and whether the defendant police officer played a role in creating the dangerous situation. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight. The determination of reasonableness must allow for the fact that the police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The test of reasonableness is not capable of precise definition or mechanical application. The reasonableness inquiry is an objective one. The question is whether an officer's actions were objectively reasonable in light of all of the facts and circumstances confronting him, without regard to his underlying intent or motivation. If you find that the state proved beyond a reasonable doubt all of the essential elements of the crime of murder, your verdict as to count one must be guilty. However, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of the crime of murder, your verdict as to count one must be not guilty. Count 2. The indictment charges the defendant in count 2 with voluntary manslaughter, a violation of Ohio Revised Code, section 2903.03a. You should not consider count 2 unless you are unable to unanimously find the defendant guilty of murder as charged in count 1. If you unanimously find the defendant guilty of murder in count 1, you are not to consider count 2. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 19th day of July in the year 2015, and in Hamilton County, Ohio, the defendant knowingly caused the death of Samuel DuBose, while the said defendant was under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force. The state of Ohio has the burden of proving the defendant knowingly caused the death of Samuel DuBose in count 2, voluntary manslaughter. Neither the state of Ohio nor the defendant, Raymond Tenzing, has the burden of proving that the defendant was under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force. These are factors that mitigate the culpability of the defendant and not elements of the crime of voluntary manslaughter. If you find evidence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite the defendant into using deadly force, such evidence can come from evidence produced by the state of Ohio or by the defendant. A person acts knowingly regardless of purpose when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he caused the death of another. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. When an act is a crime, a good motive or purpose is not a defense. Cause has been previously defined for you. Under the influence of sudden passion or in a sudden fit of rage means there is serious provocation occasioned by the victim that is reasonably sufficient to incite a person into using deadly force. It is an act done in the heat of blood without time to reflect or for passions to cool. For provocation to be reasonably sufficient to bring on sudden passion or a sudden fit of rage, you must decide that the provocation was sufficient to arouse the passions of an ordinary person beyond the power of his or her control. When deciding whether the defendant was actually under the influence of sudden passion or a sudden fit of rage, you must consider the emotional and mental state of the defendant and the conditions and circumstances that surrounded him at the time of the act. Deadly force means any force that carries a substantial risk that it will approximately result in the death of any person. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. The defendant, Raymond Tenzing, maintains that his use of deadly force against Samuel DuBose was reasonable and lawful in the exercise of his official duties as a police officer and therefore justified because he feared that the actions of Samuel DuBose would cause death or serious physical harm to the defendant. Justified use of deadly force has been previously defined for you. If you find that the state proved beyond a reasonable doubt all of the essential elements of the crime of voluntary manslaughter, your verdict as to count 2 must be guilty. However, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of the crime of voluntary manslaughter, your verdict as to count 2 must be not guilty. You will have with you in the jury room the following verdict forms. No inference is to be drawn from the order in which the court reads these verdicts. Verdict in count 1. We, the jury in the issue joined, find the defendant Raymond M. Tenzing not guilty of murder, a violation of Ohio Revised Code Section 2903.02a, as charged in count 1 of the indictment. There are 12 lines, one for each juror, with one indicated where the foreperson will sign. Verdict count 1. We, the jury in the issue joined, find the defendant Raymond M. Tenzing guilty of murder, a violation of Ohio Revised Code Section 2903.02a, as charged in count 1 of the indictment. 12 lines, one for the foreperson. Verdict count 2. We, the jury in the issue joined, find the defendant Raymond M. Tenzing not guilty of voluntary manslaughter, a violation of